grants you knowledge and activates the power of the people. Join me, Consolata Chibalonza, every Wednesday at 9 p.m. on Know Your Law, only on EBN TV. Welcome to EBN Prime Edition. This is Know Your Law. My name is Consolata Chibalonza, and as we had discussed earlier, today we have a guest in studio, a guest who knows very much about the law and the law of the land, which is the Constitution. What does the Constitution provide? What does it say, and how does it help us as the common mwananchi? With me is none other than Wakili Paul Mushiri, and I will allow him to introduce himself, to tell us a little bit about himself, what he does, what makes him a lawyer. Welcome, Wakili.
Thank you, Chibalonza. My name is Wakili Paul Mushiri. I'm an advocate of High Court of Kenya, and I'm also a managing partner in the law firm of Macharia Gaitho and Murigo Advocates. And I practice law here in Nairobi, but of course we have, due to the digital space, I practice virtually all the courts in the Republic of Kenya. Yes.
And does that work really well, like the virtual representation? Is it same as the physical one?
Yes, it is of much advantage because you can be able to handle several matters at a go. You can have a matter in Mombasa, you can have a matter in Nairobi, you can have a matter in Nyamira, in Kisii, in any other place of the Republic of Kenya, and you can be able to handle them at the same time while you are seated at your comfort of your office.
And without much ado, let us just get straight into it. So currently, as we speak, there is this issue with Ahmed Nasir, who was banned from practicing at the Supreme Court. Number one question on the table: is that allowed?
Now, when in the practice, like judiciary is an institution.
Yes.
As an institution, it has its own ethical conduct of operations, and all the advocates, including judges, because judges are first advocates.
Yes.
So what happens in the training? They are taken through what we call the professional conduct, and the court can punish anyone who it thinks that one, they are not obeying the ethical requirements of the court, and two, anyone who disobeys the orders of that court.
Yes.
they can be able to punish them.
Yes.
So what we are seeing, and three, the court and the judges. When we are talking about the court, we are talking about the judges and the magistrate. We call them judicial officers. They can decide if they are conflicted or if they think they are not going to deliver justice. When a person is presenting their case, be it an advocate, be it a client, they have a right to recuse themselves. That comes from, one, the judge may have had a previous interaction with you in person, which then precludes them from giving a fair, unsided decision.
Okay.
Two, the judge the judge, when they were advocates, they may have acted for you.
Okay.
So in that case, it's only fair they recuse themselves.
Yeah.
Three, the judges may, because of your conduct, be inclined to be biased against you. In that case, then they will also recuse themselves. So, in essence, you see, the court, beside the recusal, the court can prescribe how it wants the persons appearing before it to conduct themselves. If the court says, in several courts, some are told, don't come late, or don't disturb me once I've started my course list, or don't do a number of things that the court will say. So in essence, the court has the power to punish anyone who disobeys it at that particular moment.
But what now happens to the client of this particular lawyer or advocate who is now responsible for this court that is in session?
Now, in the training as advocates, there is a rule that every advocate or every client has a right to choose the lawyer to represent them. Of course, what we've seen, it's something that we have not seen recently, where the court makes a pronouncement that a particular advocate should not appear before it.
Yes.
Now, what you understand, it is the right of a client to choose the advocate of their choice. For whatever reason, they may choose, they want Advocate Moshiri because they have a rapport with him, or is somebody competent to represent them. For whatever reason, then the court has no say as to who you choose to represent you. It is your choice, it is your case. You know, in the system we have in Kenya, the practice of law in the judicial system, the legal systems we have, the court ought not to take sides.
Yes.
When you talk about legal representation, the client is given liberty to choose who should represent them in court. And the court cannot force a client to choose an advocate who they are not comfortable with.
Yes.
Now, what should happen, or what the law envisions, is that as in line to the fair hearing and fair trial, every person should be allowed an opportunity to choose advocate of their choice. If they choose to stand with a particular advocate, the court should not dictate. Now, what will happen in this scenario, of course, we're seeing this unprecedented, because we're seeing a situation where the clients may be forced to have an advocate not of their choice, but out of the circumstances. Yes. But then the clients may also choose to have them, the advocates, as their advocate, and there is nothing the court will do. Because that being the case, then the only solution would be that case will not, that advocate will not have audience before that court. And the client cannot be punished for choosing an advocate.
Yeah.
Now,
you see, now for this instance, yes, they chose their lawyer.
Yes.
They decided we're going with Ahmed Nasir, case in point. But then now you come and look at Ahmed Nasir. It is the court that has refused the services of Ahmed Nasir. So what happens to now the client? Do they go choose another one, or will now the court choose another lawyer whom they deem fit?
One, the court cannot choose a lawyer for anyone.
No matter what.
There are limited instances where a court chooses a lawyer to a client. Now, in the system we have in Kenya, when someone has committed a felony, these are capital offenses, and they do not have an advocate to represent them, the court, by its own motion, may select an advocate from the pool of advocates who are qualified to represent clients on the pro bono services. But then when a client can afford to choose an advocate, they have the liberty to choose the advocate of their choice, and the court has here your advocate. The other option is but you also understand the dynamics of a case and how the case works. If when we are talking about civil cases, we have the person who goes to court. At times we call them the applicant or the plaintiffs. Sometimes we call them even the claimants. And then we have the people who are taken to court. We call them the defendants or the respondents. If the case, as it is in favor of the defendants, it would be in their interest that the case does not move further. You understand?
Okay.
If the case is in the favor of the client, it will be in their best interest that the case does not move further.
Yes.
So, based on the circumstance of a case at any particular time, if if the case not moving does not affect you in any way, then why should you have the case move? Because you see, going to going to court is a contest.
Yeah. Yes.
Where the court will weigh whose evidence are we convinced to adopt.
Yeah.
Now, if the court is convinced to adopt the evidence of the plaintiff or the applicant or the claimant, then the case will be determined that then probably the claimant may have the case still to their advantage. So at that point, the respondent doesn't care much whether the case proceeds or not. They have won.
Oh, indeed, law is something very interesting. So, apart from that, there have been cases of quack lawyers going around. So, number one telltale signs of a quack lawyer. How can I know, as a common mwananchi who knows nothing about the deep stuffs of law, how can I really tell a quack lawyer?
Now, I wish to draw a distinction between a lawyer and an advocate.
Okay.
A lawyer is anyone who is in the legal training. They have not become advocates as yet. Advocates, these are people who have been allowed by the High Court of Kenya to practice as advocates. How do we know that they have been allowed to practice? Their name has been entered into the role of advocates, which is the mandate of the High Court of Kenya. When you see people saying so and so has been admitted to the bar,
yes,
it means that their names have been entered into the role of advocates. The role of advocate, this is the entry. It's a record that contains the people who have gone through the legal training and they have satisfied what the law says in terms of being allowed to practice. Which law allows advocates to practice? The Advocates Act and other regulations that have been made by the Law Society of Kenya. So an advocate is not the same as a lawyer. A lawyer, even the person who is in a law school is a lawyer. The person who is in the Kenya School of Law is a lawyer. The person who is in a legal training is a lawyer. But an advocate is a person who has been allowed by law and admitted to the role of advocates to practice law. How do you know whether one is a lawyer or not? That database for all the advocates admitted to the bar, it is provided for and it's available online in the website of the Law Society of Kenya. When you use your device to check search advocate, you'll go to the website of the Law Society of Kenya and you can search the name of the person who is purporting to be a lawyer.
Okay.
If you go, for example, today you search advocate, you go to the website of the Law Society of Kenya and then you check Chibalonza. You'll see whether she's an advocate or not.
I'm not there.
And if they are there, you'll see their status. Are they active? Are they inactive? Are they suspended? You see. Where do they practice? Where can you find them?
Okay.
So all the advocates who have been admitted to the role of advocates, their details, their database are available online. In the search engine, the Law Society of Kenya, you search advocates, you type their name, you get their details. But for a lawyer, you can't get those details. They are students.
Yeah.
You can't get their details.
So what happens when, following the cases that we've had, for instance, the latest case was one who picked a name that was already there and then went to the court, represented people, and in fact won some cases. And once he was realized that he was a quack lawyer,
so
the court took the cases back.
I wish to cut you short. The issue of winning a case is another debate.
Yeah.
How do we know he won? Which cases did he win? Who are the people he won those cases for? Do you know any?
No.
Those are stories in the grapevine. But the truth of the matter is, you cannot purport to win a case. Well, you cannot even mention a case. Well, there is no record. There is no one coming to claim that that was my advocate, he won the case for me. So the issue of a quack lawyer winning a case is not substantiated, and we can't believe in such a narration. So the issue of being a quack lawyer, when for such a case and it's in court, he has been charged with a criminal offense. One of personal theft, identity theft. How do you impersonate someone and you purport to practice as an advocate? Two, when such a person obtains money and he is given money in belief that he's an advocate, then that is obtaining money by false pretense. So, and then there are other regulations that you are practicing without authority. Of course, when you look at the legal training and the guidance on how the legal practice is to operate, there are regulations that govern how advocates ought to conduct themselves. Advocates, and I'm not talking about lawyers, because lawyers, they cannot be governed by the Advocate Act. Advocate Act and the regulations made by the Law Society, they govern those people who have been admitted as advocates. So the penal code and the other laws, they prescribe on how we can punish this person who has not been admitted as yet. Yes.
So he will be punished as a common mwananchi, not as an advocate, because he's not.
He's not, and he's not an advocate because he has not been admitted. Now, when you come to the punishment that advocates can get, one of them, they may be deregistered from the law of advocates. Two, they may be fined because of their conduct. And three, they may be given a warning. But you see, this individual, this character is not even a lawyer. So he cannot be struck from the record. He is not even on the record. Two, he cannot be fined or be compelled to pay a client per se, because that is the work of the commission inquiring the conduct of lawyers. So his offenses or acts and omissions, they'll be treated in a court of law because he does not subscribe to the systems that governs the conduct of advocates. Yes.
Is this statement true, that your case is not as strong as your evidence, but it is as strong as your lawyer, as your advocate is?
Now, as I said, advocacy and the cases, they are determined by so many factors. Winning or losing a case is determined by so many factors. When we say, or why we say an advocate is a good advocate, because a good advocate knows the law. A good advocate knows how to integrate facts with the law. A good advocate knows general principles of law and also knows exemptions to those principles because they are there. So you may have the facts, you may have the evidence, but you cannot integrate evidence, fact, and the exemptions to those facts. While another advocate, even when the case seems not strong, they can be able to understand and contextualize the positions in favor of their client.
So depending on the kind of advocate that you have, and how well or how versatile the advocate is with the case in question, now that has a long way to go with your case, right?
Yes.
Why then do we have cases dragging on for years and years and years? Why not just give out the verdict once and for all?
You see, the dynamics, and I said, the legal system we have in Kenya, unlike in some other jurisdictions or some other places in the world, in Kenya, the cases is determined by the weight of the evidence, not the amount of the evidence, because evidence is not counted. Evidence is weighed.
Okay.
and we talk about, in law, we talk about property value. The property value that the evidence have. It is not the amount of evidence you take to court, but what is the weight of the evidence you take to court? What the court does is to weigh the weight of the evidence brought. Now, in several cases, the success, for you to succeed, you have to prove at least 50 plus 1. Your weight has to be, on a scale, it should be 50 plus 1.
Okay.
When you're talking about a criminal case, it's almost 100%. Now, for you to succeed, and the reason why cases drag in court, there are a number of reasons why the cases drag in court. One, you may see that a case is very complex. What would make a case complex? One, it has so many parties, it has so many advocates, it has so many exhibits or evidence that needs to be to be presented, to be interrogated. Now you may find, for example, a good case in point, the case for Paul Mackenzie. They are charged, I think, alongside other individuals, about 90 of them.
197.
Yes, and the counts that they are facing is 238 counts. Every count is a breach, is a legal breach. Prosecution needs to have evidence for the counts they have taken to court. You'll find they may have maybe over 100 witnesses.
Of course.
These accused person, each accused may have their own advocate. So at every instance of the evidence presentation, every advocate for the accused will have a chance to cross-examine the witnesses brought by the prosecution. Now you may see, even in a 1 week, they may not be able to finish with one witness. And that applies to even other civil cases. Depending on the complexity of the matter. You may find that maybe a matter comprises of a transaction of high value, monetary value. The higher the value, the higher the requirement of proving it.
Yes, true.
That therefore means the higher the amount, or the higher the standard and the burden of proving by way of evidence. So you see, then the cases may take long.
Yes.
Another reason, of course, it also depends with the type of case. Like when you talk about succession cases, some of them take very long. Why? Because of back and forth that people have. You may find a case that was filed in 1990 or 1993. It went, there was a grant, it was confirmed, the property were divided, but later, maybe after 20 years, the family discovers there was some other properties that had not been administered. Or there is a dispute between the family members on how the properties are to be divided. So every dispute has to be heard by the court. The court has to make a decision. Every party has to present their side of the story so that the court can decide. So because of the back and forth, at times you find that the cases may drag. Another reason would be there are not enough judicial officers to deal with the case. And sometimes you will find that a judge has over 70 matters in a day. Some are mentioned, some are hearing, some are part heard, you see. So depending on the weight and the requirements that or the effort that the judge has to put, you see that then it becomes not easy for them to be able to conclude matters fast.
What does it take for one to become a judicial officer? Maybe someone is seated there and is like, I don't want to become an advocate, I just want to become a judge. I just want to say guilty, not guilty, go home, get your bail. What does it require?
Now, for you to become a judicial officer, you must first be an advocate.
Compulsory.
And who is an advocate? An advocate, this is a person, as we said, their name has been put in the role of advocate. Now, when you're talking about judicial officers, we have now we have what we call small claims courts. We have the magistrate courts. Then we have superior courts, where we have the High Court, the Court of Appeal, and the Supreme Court. Now, in every rank, there is a requirement in terms of the years of practice.
Okay.
For you to become a magistrate, you may see the Judicial Service Commission may prescribe at least 3 years in practice. For you to become maybe a judge or of High Court, Supreme Court, or Court of Appeal, there is a time, 10 years, 15 years of practice as an advocate for you to become a judge. So becoming a judge is a process that starts by you becoming an advocate. Once you're an advocate, then after some time you may qualify in term as a result of your duration of practice.
So are you called? Are you like, do you get like an email? Call me, Shiri, now you are the new magistrate.
Now, the body that employs judges or judicial officers is known as Judicial Service Commission.
Okay.
Judicial Service Commission is a constitutional body that is mandated by the constitution we gave ourselves in 2010 to employ judges. Now, like any other employer, when there is an opportunity, they send invites or they send invites. People make applications, then they are interviewed. First they are shortlisted, they are interviewed. Then once they are interviewed, they are sworn in as advocates.
Exactly.
So it's not an appointment per se, but it is a process where you put in your application. Once it is considered, then you are appointed. And you see, the appointment of judges and magistrates is not the same. Like for judges, the appointing authority, there is the nominating authority and there is appointing authority. They are appointed. Once they make their application, the process of recruitment is done by the Judicial Service Commission, but ultimately the president will appoint them to the position of the judges, like what President Dr. Ruto did by appointing the judges of the Court of Appeal that had previously been qualified by the Judicial Service Commission to serve in that capacity.
Wow. Okay. Time is flying. I don't know how. I lost track of time. But what is your final? What is your takeout to fellow Kenyans who are listening and they want to go and seek legal advices? What would you tell them to look out for? What do you advise them to be on the lookout for?
One, it's good that if they want to approach an advocate, it's good to do a background check on that advocate. How do you do that? One, there are advocates, there are platforms you can inquire. If we meet on the streets and I tell you I'm an advocate, I want you to give me your case, before you give out your money to a person who is purporting to be an advocate, make sure that you have done some background check on them. One, you know where you can find them. Two, you know whether they are indeed advocates. And three, at least you are satisfied as to their competence. Because one of the requirements and one of the professional requirements as an advocate, you should represent your clients in an honest manner, in an open manner, in a professional manner. Because advocates or legal, being an advocate, you join the legal profession. Just like any other profession, and unlike a career, a profession, it is meant for the public good.
True.
Where your greatest service would be for the benefit of the members of the public. So before you settle to have someone to represent you, also be sure of their character. Be sure of their professional standing. Nowadays, you can, in the Law Society of Kenya, you can get a certification of your moral conduct. is this a person who you can trust with your funds? Is it a person who is forthright? Is it a person who is appealing to you? So it is very easy, and then you have a choice. The client is the boss.
Yes.
They can choose who to represent them, but then before then, make sure that you are choosing someone who is competent enough to represent you in court.
Well, thank you. Thank you very much, Mr. Muchiri. This was an amazing session. Wish we could go on and on and on, but sadly we have come to the end of today's Know Your Law episode. My name is Consolata Chibalonza. It has been an amazing time with you. I hope all your questions have been well answered. And in case you have more, please do make sure to leave your comments on please make sure to leave your questions on our comment sections, and we'll be able to get back to you either directly from our Akili or even from the little that we have gathered in the show. This is EBN TV Prime Edition. I'm signing out. See you tomorrow morning for Morning Alive. Until next time, God bless.
The 2010 Constitution, as of the 27th of August, became the rule of